Hello everyone and welcome to this new episode of the Privacy Rules Meet the Member podcast. Today I'm joined by our colleague from Poland, Agnieszka Wiercińska-Krużewska from Wierciński-Krużewski, and I'm pleased to introduce her to all of you. Hello Agnieszka.
Hello, good morning. Hello, good morning. I'm happy to be with you.
Nice to speak with you and thank you for being here today with us.
It's a pleasure. Thank you.
Okay, Agnieszka, let's start immediately discussing about what's happening in Poland. And before of that, I would like to ask you to give us a brief overview on which is the data protection regime in Poland, considering also the GDPR implementation that we discussed in our last webinar that was in relation of the first year implementation of the GDPR. But we would like to know more about the main characteristic of the regime that you have there.
Mm-hmm. Thank you very much again for being with you, and I'm very happy to be sharing some of the aspects of the GDPR implementation in Poland. And I think that I'll start with saying that Poland is a big market. It's relatively mature. And I think that because the economy is doing quite well, it's still very attractive for investors. That's why the GDPR is one of the aspects that many of the investors, or most of them, look into in order to make the risk assessment while investing in Poland. So I think that the GDPR regime that is binding in whole European Union is very attractive from the point of view of the investors because it's common. So after years of different legal regimes, although they were based on the directive, but still there were many differences among the member states in how the how the data protection was protected. Some countries, for example, had opt-in, some countries opt-out option. So every time someone was investing in Europe, they had to assess country by country. With the GDPR, this is over, more or less. The GDPR introduced a very common legislation regarding the protection of data privacy. It is quite conservative, I would say. So in comparison to the rest of the world, the data protection regime in Europe is very strict. So I spoke with many of the colleagues from other jurisdictions, and they would normally say, well, the data is protected, the personal data is protected based on the constitution or some other protection of personal interests regimes. However, there is no specific legislation with respect to data privacy. So I think that really GDPR, on one hand, as I said, is quite strict and conservative, especially for some investors from Asian countries and from the United States. But on the other hand, it gives the security that is the same all over Europe. So I think that this is to the benefit of the investors coming to Europe. Although one have to remember that GDPR is a basic legislation, so it's a regulation that applies all over Europe, including Poland. However, there are specific laws in every jurisdiction that needed to be changed. And in Poland, I think it was more or less about 100 laws that needed to be changed in order to comply with the GDPR. Public procurement, the way public tenders are run with the information that has to be included and revealed during the public tender, banking system, insurance law, medical law, so all the life science and medical regulations. So there are many laws that require very specific changes in order to comply with the GDPR. So a GDPR specialist, the data privacy specialist, is always looking at the GDPR, but it has to be aware of all these particular laws that are in place, depending on which sector we are discussing. And of course, next to the specific legislations sector related, there are some legislations, like, for example, labor law, that I guess underrun the biggest change in what kind of data can be processed by the employer, what kind of data can be processed in the recruitment. There's a whole section about monitoring of employees in the workplace. So these areas, they're really very sensitive. And I guess that from the point of view of the lawyer, these are the areas that we looked at most with clients' questions.
And among those areas, there are some that creating more discussions related to privacy, or it's been implemented almost everything without big issues?
Well, during the implementation process, there was a lot of, there were many discussions. So it took almost a year to draft the final law implementing the GDPR. So the data privacy law that changed all these other legal acts. For example, profiling in the financial sector. So there were a lot of discussions about how far the profiling can go. So there was a lot of lobbying from the financial institutions, to make it less strict, especially in cases like fraud, in cases of the credit valuation for consumers. So there were discussions. So it wasn't a process that was smooth and without any problems. Mm-hmm. I think that what was the problem with the first year of GDPR application was that many companies and journalists and media concentrated on less important things, like we say, like stupidities of the GDPR. For example, that some of the schools refused to call students by family names because they were saying that they can't call them by family names because they're infringing the GDPR. Or, for example, in some of the medical institutions, they were giving people nicknames while calling them to the doctor's office because they were saying that this is also GDPR compliant. So there were a lot of really funny things which made people believe that GDPR is the most scary and the most incredibly difficult act that makes all the people's life very complicated. And I think that this caused the problem that both media and lawyers didn't really concentrate on the most important aspects, like saying, yes, this is an important piece of legislation. This gives you certain rights. It gives you certain protection, and that the main reason for the GDPR was really to protect your data in the internet, social media, profiling, advertising, marketing. This is really what was the core of this implementation. And we really concentrated on things that were funny, especially from the lawyer's point of view. They were really funny. But yes, that caused a lot of problems because that caused a lot of misunderstandings.
And what about the possible changes that you will have in the future? We spoke about the past and almost about the how things are going now, but do you have any idea on how things may move forward?
I think that we will, for the next 1-2 years, I believe that in terms of legislation changes, we will have a pretty steady development, so no major changes. But I think that the most important is to follow the interpretations. So both the office, the regulator for the data privacy, makes a lot of interpretations of the law, issues a lot of guidelines, and not only the Office for the Data Protection, but for example, the Ministry of Digitalization also issues some of its interpretations. And then, of course, we will go into the stage then that courts will start to interpret the law. following some of the decisions of the regulator, which will be appealed to the court. The courts will start to investigate how the law should be interpreted. And this is, I think, something that I'm really looking forward. This clash between the administration, so the regulation, which is heavily administratively driven, with the courts, who more or less look at the law from the point of view of protecting individual interests, and valuing whether, whose interest is more important, whether individual interest or maybe some other interests of the administrator, of the controller. So I think that these are really these developments that I'm really looking forward to see in the next 12 months.
And in speaking about that, I think you expect to have such kind of developments, in particular in that areas in which you experienced the practical, you had practical experience during your professional activity. So I would like to know in which you are interested more, since and which are your main practical experiences on the implementation of privacy frameworks.
Yes, I mean these practical examples, they pop up every day. But I think that the two that I would like to mention, which really caused a lot of problems from the corporation's point of view, client's point of view, is geolocalization. So the GPS that is installed in companies' cars, and whether the company can monitor the use of the car in the private time of the employee. So if the employee is given a car for its employment purposes, but still the employee can use the car in its private time. And it's very difficult to switch on, switch off the GPS regarding whether the employee is using for the private purposes or for the professional purposes. So there was a lot of discussions. There were one interpretation coming from the Polish regulator. There is one coming from the European regulator. They're kind of conflicting. But I think that at the end of the day, it's very difficult to implement a system that would distinguish those two usages. And I think most of the companies, we try to come to the conclusion that it is in the legitimate interest of the employer, of the controller, to process the data also from the private use, but with a very, very limited availability. So only on a very need-to-know basis, with a very restricted access to such data. So for example, if the car is stolen or if there was an accident. So these are very specific examples where the employer can access the data coming from the private usage of the car. So I think that this is very practical, but it went through the whole market because it's very, very common in Poland that people use companies' car for private use. The second area I would say is M&A transactions, and the use of personal data or processing of personal data in the due diligence exercises. It is in the interest of the purchaser to investigate the target in order to assess the possible risk, including many related to data, to personal data. So also structuring the M&A transactions and the due diligence exercises to sign, for example, the data processing agreement with the potential buyer, or to make clean rooms where only lawyers have access to the personal data in the process of due diligence without giving access to the potential purchaser, because there is no legitimate interest in processing such data. So I think that this, and also maybe M&A related, is the asset transfer deal. So no, when you're buying shares, it doesn't really matter because the controller remains the same. But in any kind of asset deal, you're shifting the controller from the previous owner of the assets to the new owner of the assets. And it's also quite complicated in many respects to find this legitimate grounds for processing, then follow the information process to the employees connected with the assets, and obtaining the new consents or the new interest on new basis for processing.
Okay, so thank you, Agnieszka. We are running out of our time, so I would like to make you just one last question related to which is your advice to people that deals with privacy in particular in your country, in general with GDPR.
I think that the very practical advice is Poland is a very it's a stable country, and I think that the regulator is so far very cooperative. So it's making the investigations. Last year there were 113 investigations, but only 2, I think, finished with penalties. So be careful, as in any other jurisdictions. Look into the particular laws like labor law, because there are some differences from other European countries. But other than that, be rational. And I think it's really something that we all have to remember. That GDPR is really about being rational.
And to use logic and apply it.
Exactly. Absolutely.
That's always the main lesson learned from GDPR. If you do things in the right way, in a logic way, and you are well organized, well, you shouldn't have big problem with this regulation.
That's exactly what you're saying, and I think that that this is the difference. So that's why I'm a fan of the GDPR, because that's exactly it emphasizes the logic that if you think about your personal data, the personal data that you store and you process, and you make the risk assessment, you're much better off than in the previous regime that really indicated 10 different manuals that you have to implement in the company, and no one really knew about them and no one really remembered about them.
Thank you very much, Agnieszka, for being with us today, and
thank you so much
all our listeners for joining us. You can find this podcast, but also all our materials on our webpage at privacyrules.com, and I invite them to follow us on our social media. And I thank you again, and I hope
thank you so much. Yeah, have a very good day. Thank you so much. Bye-bye.